We believe in the American justice system, and we do not believe in the sentencing of it all, but it is over now, and we need to go on.
That the cousin of Vincent Viafore, the man who drowned in the Hudson 2 years ago, that after the plug was pulled on his kayak. His fiancée at the time, Angelika Graswald, admitted to pulling the plug and pleaded guilty to criminally negligent homicide. She also admitted she knew he wasn't wearing a life jacket or a wetsuit, and since it was April, well, the water in the Hudson, as you'd expect, was freezing cold and deadly. She just got sentenced to, wait for it, 18 months to a 4-year sentence. Now, Graswald's behavior was bizarre right after her fiancé disappeared. You may remember some of this. She posted a picture of herself doing a cartwheel. She also posted this picture of herself kayaking. Again, she likes the water, apparently, with a caption, "If only I could paddle harder. Damn it." Classy. Her behavior, bizarre to put it politely. I want to bring in our panel right now to get their read on the case. And again, 3 gentlemen who have all been on both sides of this as prosecutors and now in their new walks of life. Jim Kasoris, criminal defense attorney in Manhattan. He sits on the board of directors of the New York City Criminal Bar Association, frequently lecturing at the New York Law School and the bar associations in Queens and New York City. Doug Von Oist, founding partner of Carson Von Oist, focusing on corporate misconduct, selected by the Legal 500, one of the most influential trial lawyers in the country. Mayo Bartlett, an attorney at the law offices of Mayo Bartlett PLLC, and a former chief of the Bias Crimes Unit at the Westchester County DA's office. It's getting bad, guys, when I can almost do this without reading it. Okay, I'm sorry.
We're going to change what we do.
Yeah, right. I'm going to read the next one. Jimmy's in the circus. No, but Mayo,
pretty soon.
I know you are the most sympathetic guy, okay? And you can find a rationale for anything. But she not only said she did it, she showed zero contrition. She knew he didn't have the wherewithal to basically help himself. How is that something that you only get as little as 1.5 years or a max of 4 years? How's that justice?
Well, I think it's an issue of proof in this case, and you're
What
looking
more do you
at...
need? She said she did it.
Well, you need a lot more than that. You've got to show that she intended the consequence. You've got to show that she actually took specific actions to allow it to occur and that those actions led to his death. And here, basically, they had entered the river well before the season for kayaking at a time where only the most experienced kayakers would even contemplate going in. Secondly, removing the plug in and of itself, experts will tell you, is not enough for the kayak to actually go down.
But did she intend him to drown? I asked that, Doug, because plug gets pulled, apparently pulled back the oar, and then after he drowns, and she knew he didn't have a wetsuit or a vest, she's then doing cartwheels and then making jokes about, with the Hudson in the background, talking about, well, we all saw the jokes. How is that not intent? How is that not motive, it seems? And how is that shown, depravity or whatever? I'm making words up as I'm going along.
Well, listen, she's clearly like a little bit off her rocker.
You're going on an edge there, my friend.
But she's a little strange. But all of that strangeness wouldn't come into a trial. She could have intended to pull out the plug. She could have intended it to be a joke, to see the guy go in the water, to teach him a lesson for being nasty to her, but not intended to kill him. That could be that simple.
And really? Wait, is that the law?
Sure.
You intend to cause distress for someone, and that distress ends in death, or foreseeable death, I would say, right? She testified she knew what he didn't have, and she knew the conditions of the water. Why doesn't that come to a higher standard than just negligence?
Well, because exactly the way you put it, manslaughter is you intend to cause serious physical injury which results in death. If you intend to give the guy a hard time, and as you say, cause him distress, it does lean more towards negligence. And I have to tell you, there was a very long hearing here on the statement. The interrogation, I think, was flawed. I think the district attorney recognized that. The district attorney was very clear that if he had his druthers, he would have prosecuted the case and tried the case, but he really did see a problem with the proof in terms of the statement and in terms of the intent.
Well, that's what I don't understand, though, Jimmy. The statement. There's audio recordings of her testifying. Clear, sober. There didn't seem to be, we've talked many times with Mayo, talks about people can coerce confessions. Certainly it didn't appear that to be the case. She seemed to be a more than willing a person sitting there in custody, sharing all the details of the story, and again, obviously not showing, major distress as she's getting ready, I don't know, to do the lotus position here in her yoga routine. So why isn't that statement enough?
Again, when a statement is taken over the course of 18 hours uncounseled, think of what you put up with us for 20 minutes or 30 minutes. Okay.
By the way, piece of information, Jimmy likes the water here. We know how we can certainly go. Like, you're setting a low standard for Deborah, but that's a separate point here. Yeah, exactly. Yeah. Right. But why can't the public just watch this Tonight Mayo and say, my God, what does it take to secure a conviction for a real penalty for a real crime?
Well, I always would look at it this way, whether a prosecutor or as a defense attorney, why does it take you 18 hours to get to the statement? So there was a gentleman, Michael Crow, actually, in New York State Bar Association had lobbied to require the videotaping of the entire custodial interrogation process, not just the good part at the end where you finally have the person ready to say what you want them to say. So quite often people have memorized the narrative that's
Apparently
been
there's
partially...
enough video, you can do a workout video here, so it's not just limited to just the magic statement.
But they're not showing you 18 hours. They're showing you when she's stretched, she's under stress, and I tend to tell you virtually everybody would behave in manners that you may not anticipate when you're under stress, and that's not the stress that you killed your spouse or significant other. So people are going to do things that are out of character, things that don't look good, and if you pick and choose little clips from 18 hours, you can make anybody look bad.
18 hours is a long time, Rich. 18 hours is a long time to be sitting in a room without a lawyer, under interrogation, sporadically.
I hear you all. If that was your client, you'd strangle them if they're doing calisthenics. That's all I'm saying. All right, coming up next, the Menendez trial, it's in the hands of the jury. We're going to take a look at what's going on inside the courthouse and also what could happen if the Senate, in the Senate actually, if there is a conviction for Menendez. Stay with us.